So good afternoon, everyone. Thank you for joining us today for this important discussion on what is ahead for innovators and creators in the new Trump administration. My name is Urška Petrovčić, and I'm a senior fellow here at the Hudson Institute. It's my pleasure to moderate this panel featuring distinguished speakers. We have with us Andrei Iancu, partner at Sullivan & Cromwell, and former director of the U.S. Patent and Trademark Office under the first Trump administration. We have next Rama Elluru, senior director of the Special Competitive Studies Project, and a former administrative patent judge. And we have Brian O'Shaughnessy, partner at Dinsmore. Thank you, everyone, for being here. So intellectual property rights have played a critical role in the United States' rise as a global leader in innovation and creative industries. Over decades, intellectual property rights, combined with the rule of law, have provided the framework that has incentivized countless breakthroughs and have positioned the U.S. at the forefront of key technological advancements and artistic creativity. In the field of technology, for example, this has enabled the U.S. to become the most technological advanced nation in the world, which has ensured broader economic and national security. Yet, over the years, we continue to see repeated attacks on the protection of intellectual property rights, both in the United States and abroad. And arguments for weakening IP rights keep gaining attention, despite the fact that numerous evidence keep confirming the clear positive effects that IP rights have not only for innovation and creativity, but also for economic prosperity and society more broadly. So my hope for today's discussion is to explore how the new administration can address these challenges and how it can lead toward the development of a reliable framework for intellectual property rights, both in the US and abroad. So let me start with the first question for our panelists. As we look ahead to the new Trump administration, what are, in your view, the most critical areas of intellectual property law and policy that need reform or perhaps attention in the coming years? And what are the key policy challenges or initiatives you anticipate that will impact innovators and creators? Director Iancu, do you want to start?
Sure, happy to. And thanks, Urška, for having us here and organizing this excellent conversation and topic that you posed. So at the high level, so just to step back, I think one of the most important things for legislators and administrators, both in the United States and frankly around the world, is to first recognize the fundamental importance of intellectual property to create a strong innovation economy. So this is at the base level and base requirement, in my opinion. If you go around Capitol Hill or governments around the world and you ask them, are you for more innovation or less innovation? Pick a side. I don't think it's a hard call. I think you will get virtually everybody, probably everybody, say, we want more innovation. But then if you ask the follow-up question, which is, so therefore, are you for stronger intellectual property rights or weaker intellectual property rights? You'll get a very mixed set of answers. Probably at least half will say, what do you mean by intellectual property rights? The others will say, why are you even asking the question? What's the relationship? And then for those who actually do know, I think it's basically split. Some do recognize that there is a positive correlation, but frankly, there's plenty of policymakers out there who, and members of the public, who actually believe that there is a negative correlation. There are plenty of people out there who say that intellectual property rights act as a barrier to innovation. Patents in particular, some people say, act as a barrier to innovation. That, innovation just happens anyway. Okay? Scientists want to discover things because that's what they do, and engineers will just invent new things because that's what they do. And only after that happens, the clever ones will just use intellectual property rights to pull the ladder behind them and block others from accessing that innovation. So there is no question that there is this argument that's being made around the world. In my opinion, it is completely wrong. It's a false premise. It is not backed up by any evidence or historical record. And the real facts are that humanity simply has never seen innovation to the scale we have seen it in the modern era, ever, without a robust intellectual property system. It just hasn't happened anywhere around the world or in history. And so until we have the recognition that those two things are connected in a positive way, then it is going to be very difficult to actually affect the changes that you were referencing towards a stronger intellectual property system. So that's number one. A corollary to this is a recognition that intellectual property is actually property. Okay? So we call it intellectual property. In the patent statutes at 35 USC, it actually says that patents shall have the attributes of personal property. Nevertheless, for whatever reason, there are plenty of policymakers out there, as well as judges, who do not give this type of property the attributes of any other type of property. For example, one of the most important attributes of property is the right to exclude. Okay? If you have a house, you have a door to your house. You have the right to exclude the people you don't want to come. And you have the right to throw out the people who are in but won't leave. For example, your mother-in-law during Thanksgiving, perhaps, that just won't leave. I'm kidding, of course, but just, if you have unwanted guests or guests that's overstayed their welcome, you have the right to kick them out. If you have a factory, if you have a piece of land, you have the right to keep out your neighbor's cows from grazing on your land. Everybody recognizes this. And or personal property, automobiles, watches, right? If you could just simply go and take any automobile you wanted, and the owner of that automobile doesn't have a say in that, and you can just go take the automobile off the lot, right? And then you can say, if you want to sue me, you can later, and 5 years down the line, I might pay you some money. You wouldn't have dealerships, you wouldn't have how would you transact in that kind of world? Everybody recognizes this when it comes to real property, to business property, to land, and to personal property. The exception is intellectual property. They somehow have this mental block that intellectual property is a free-for-all. Once the idea is out, they argue, it is a non-exhaustive type of a property. In other words, I can have it, and because it's just an idea, you can have it as well without exhausting my rights. But it's false. As soon as you exercise the same intellectual rights, then that diminishes the value of my rights. So it is, in fact, exhaustive, like any other piece of property. And in fact, the Constitution, which creates these rights in the United States in the first place, at Article 1, Section 8, Clause 8, says that what's being granted to inventors and authors is the exclusive right. Not just any right. It's the exclusive right. That is in the Constitution itself, which is the most important attribute of property. So what's really important, mandatory for policymakers, judges, in the United States and around the world is to recognize that, first of all, as I said, those two things in combination, that you need intellectual property rights to actually have creativity, innovation, and whatever artistic creativity as well, number one, and number two, that those rights are property rights. From that perspective, everything will flow in the right direction, in my opinion, and we can talk about what those things are. And I'll just end with this for this question. These points are particularly important in a free market economy like the United States and our Western allies, where you do not have, and we do not want, a centralized government that dictates where people should invest or invent, that can distribute the money to create those innovations. And we are left here with, and I think we've greatly benefited from, the free market system, where entrepreneurs will risk their livelihoods and their resources, and will try and fail again, and then finally succeed. That is what creates the most dynamic innovation. It has allowed the United States and the free markets to come to a position of technological leadership in the last 250 years, like never before in human history, and so it works really well. But for it to work, there has to be a system of laws, a rule of law that's dependable, and that incentivizes the investments and protects those investments from appropriation or misappropriation once successful. And we don't have any other tools. If we're not going to have a centralized economy, and we don't want it, and if we're not going to just simply hand out money from the government, and we don't want that, then what you're left with is the free market system, and that has to be backed up by a robust by the robust rule of law, and that's especially important here. Not the same in a centralized economy like China, for example. Although they have IP rights there, and we're going to talk about that as well, and it's important that they do, but it's just a completely different dynamic. And if we don't have that here, then we basically have nothing.
Yeah. Thank you, Director Iancu. Very simple but critical point, really recognizing the basic that IP rights are property rights and should be recognized as such. Rama?
Thank you, Urshika. Thank you, Hudson Institute, for having me here, and to make my general counsel happy. The comments I'm about to make are my personal ones and are not necessarily attributable to the organization for which I work. So I want to highlight something that former Director Iancu pointed out, and that's the importance of innovation. To set the context for my comments, I was detailed to the National Security Commission on AI from the USPTO, thanks to former Director Iancu, where I served as an administrative patent judge. The National Security Commission on Artificial Intelligence was an independent commission that was stood up by Congress to look at the intersection of AI and related technologies and national security. Congress was seeing two signals, one outside of China that was reorganizing itself around a technology, and a signal from Silicon Valley saying that there was going to be this transformative technology coming. And so they set up the commission, which was successful. A lot of the more than 100 recommendations were adopted by Congress and many more by the administration. And when that commission dissolved, the chair of the National Security Commission on AI funded this nonprofit, nonpartisan initiative called SCSP. And I point that out because when we started these conversations in 2019 about the global competition, there was a lot of skepticism. People thought we were over-exaggerating the problem. And those perspectives have dramatically changed. We are in no doubt in a global competition. And that competition has changed drastically. It's not just China, now it's Russia, North Korea, Iran. And at the center of this global competition is technology leadership. Tech leadership determines the nations that are going to have the economies that prosper, societies that prosper, as well as military might. So I think innovation is very important to maintain that tech leadership. I think the administration, based on what it did during the first administration, sees that as well. I think that we have national intelligence strategies, we have national security policies. Given IP's transnational nature, we also need comprehensive IP strategies. I think that the goal of these IP policies should be to incentivize, expand, and protect intellectual property rights. I think it's also foretelling. The first Trump administration is also foretelling of what we might be able to see. Trump has highlighted the importance of the U.S. leading in AI and other emerging technologies, and the importance of this being strategic to the global competition. He issued an executive order on AI in February of 2019, almost 5 years ago, which started the American AI Initiative. He prioritized AI and R&D, promoted AI education as well as the workforce, and encouraged international collaboration to the extent it protected U.S. technologies without stifling innovation here in the U.S. And he frequently framed the tech leadership with respect to AI and other emerging technologies as being critical to global competition. So I think we will see more of that as well, and I think intellectual property rights are the strongest lever for innovation.
Great, thank you. Brian?
Thank you, Arushka. Thank you for having me. I'm very pleased to be here today, and I guess I would start off by saying I endorse and adopt everything that came before. They took all the good stuff, but I think that Thoreau famously said, "Though a man build his home in the woods, if you build a better mousetrap, the world will beat a path to his door." And I would retort and respond by saying, not unless he has some form of intellectual property protection. And so, intellectual property protection is essential for the development of new technologies. For all the reasons Andrei said, the development of intellectual property regimes coincided with a tremendous growth in technology. You might say that it fueled the Industrial Revolution. John Fitch was famous for his first steamboat that ever plied the waters of the United States. He was a very savvy marketer. He approached the framers while they were in Congress and invited them to come out to the Delaware River and watch the demonstration of his steamboat. And at the time, it just so happened that the framers were talking about things like intellectual property, and they were all very skeptical about the way the Crown had treated intellectual property. And they went out and they watched his steamship ply the waters, and they said, well, this is something new. If we're going to elbow our way onto the world stage, we have to do that through technology, not by being a solely agrarian economy. And so they went back and they actually then put into the Constitution Article 1, Section 8, Clause 8. And it was different than any other IP system that came before in that it was dedicated to the inventor and the author and devoted specifically to promote the progress of the useful arts. And so there are very careful limitations that the framers put in place. And I think we need to keep that in mind. We do seem to see throughout history these cycles of skepticism being expressed toward intellectual property. And it comes from both the right and the left for reasons that befuddle me, frankly. But it seems that there are some people on the right that think that it's all about tort reform, and we've got to stop these trial lawyers from exploiting the patent system. And on the left, it seems that people are confusing it with monopoly. And so, as Andrei said, this is a property right. It's tied to something that was never in existence before. It was created by the inventor. And so it's not a monopoly. It is, in the very John Lockean sense, it is dedicated to someone who has taken out of the commons, improved it, turned it into something useful, and for that, we should give them a property right. And that property right needs to be an exclusive property right and the right to exclude others. Because without that ability to exclude, it's just not worth anything. Then it becomes a compulsory licensing regime, and that's just opening the door to, I would say, exploitation and people taking advantage. And then you're just quibbling about the value, which is ultimately going to be decided by a judge. And the judge, of course, knows nothing about the industry, knows nothing about the market, and certainly knows nothing about the technology. So, I think it's important that we continue to educate the public about why the IP system is important, what it does for our economic advantage, what it does for our national security, because you're exactly right. We have seen China, for example, I think is the most egregious in terms of exploiting its patent system. I'm old enough that I can still remember everybody saying, well, a Chinese patent isn't worth the paper it's written on. Well, that tune has changed a lot in the last 20 years, and when you run an autocratic regime, it's very easy to do. You don't have to go and convince the public that the patent system is a good idea. But now they're manipulating their IP system in tandem with their antitrust regime to force technology transfer and to threaten those who don't engage in technology transfer in the form of trade secrets and other essential components of intellectual property with the threat of jail time. And so, this is clearly an issue of economic warfare, if you will, across borders. China is not shy about making it very clear that it intends to achieve dominance in technology, therefore economic dominance, and therefore warfare dominance. And so we need to be very mindful of that as we approach our own IP system, and it's essential that we innovate our IP system such that it is capable of stimulating the kind of technology growth that we need to sustain our economic advantage and our national security.
Thank you, Brian. And Director Iancu, actually just following up on this topic of the global race for technological supremacy in key sectors. We have discussed AI, but also quantum, advanced mobile communication. So this race has really intensified in the last years. What role do you think intellectual property rights play or should play in promoting U.S. technological leadership in these key areas?
Yeah, so as we've said, if we want them, thank you. I didn't. Yeah. Anyway, if we want to succeed in these areas and any other areas of innovation, you have to have a robust intellectual property system, as we've said in the last few minutes here. And to Brian's point, there's always in history been a tension, between those who want strong intellectual property rights and those who want to weaken them or eliminate them completely. I mean, it was from the very beginning with Thomas Jefferson, who first said that patents are an embarrassment to free commerce. But then he was really the first patent examiner in U.S. history, and he recognized the importance of patents and said that patents have given a spring to invention beyond his imagination. And you always have that tension. However, over the arc of history, modern history, you have never had an innovation economy without intellectual property rights. And those who advocate for the weakening of those rights or the elimination of those rights, they better come forward with specific evidence, because we actually have the evidence of history that we always led in the Western world, and since the founding of this country, we led the world in technological innovation. And that was good for the world, it was good for humanity, and it was always under the auspices of a robust intellectual property system. If they want to eliminate that, they better have real good evidence that it's going to work, because there is no such thing to date. So that's going to apply for anything that's coming down the line as well. AI, quantum, as you said, biotechnology, personalized medicine, new energy sources, batteries, and whatever, cybersecurity, whatever it might be. We have to make sure that our legislators and administrators know that in the United States and in our allies. Now, the other thing that's really important is to recognize that innovation, not only doesn't it happen without IP, but it also doesn't happen without manufacturing. There is a significant fallacy that's permeated the West and the United States in the last few decades when we approach the concept of globalization for our economy, that you can divorce innovation from manufacturing at scale. And the reality is that the old saying that necessity is the mother of invention is actually true. And unless you have factories and people working hard, sweat of their brow, and trying this and failing and trying that and failing and ultimately succeeding because they need a solution that they don't actually have, it's really hard. I mean, you're still going to have invention, but not at scale. So the idea that you can put all of your factories in China but have the innovation in the United States, in the long run, that's not going to work for an innovation economy, in my opinion. It has all sorts of other problems too, with our workforce and all sorts of other issues. So, in my opinion, it's really important to reverse course on that and reshore a lot of our advanced manufacturing, especially in the areas of technology that you have mentioned. And you actually cannot do that without a robust intellectual property system here at home. All forms of intellectual property, robust patent protection, robust trade secrets protection, all sorts of things to make sure that companies want to bring them back home and actually feel safe that they're going to be in a robust intellectual system of laws. And there are obviously other issues there and other ways to get manufacturing back at home and other reasons to do that as well. There's tax incentives and tariffs people are talking about, all sorts of things. But to me, you need that holistic innovation, manufacturing, and protection of law, that virtuous circle for us to succeed.
Thank you. Brian, shifting a little bit topics. You mentioned earlier already price control, but in general, talking about price control, particularly for drug patents, that was a very big issue in the Biden administration, which was notably supportive of such measures. How do you anticipate the new administration would look at this topic?
Well, the new administration, I'm very hopeful, will divorce itself of this notion that somehow patents can be used as a form of price control. I think that there is a much more nuanced recognition about how the IP system works, and I would expect that they would affirmatively withdraw the NIST guidelines, which famously proposed using price as a motivation or a justification for exercising the march-in power under the Bayh-Dole Act. So the Bayh-Dole Act provides for 4 instances by which the funding agency can march in on a license if certain conditions are met, and price is nowhere mentioned. And it's specific, the statute specifically says these are the only 4 bases. Now, in the Biden administration, they issued the guidelines for actually using price, notwithstanding the language of the statute. And so NIST published the guidelines just about a year ago. And among other things I found somewhat amusing is that it starts off in the preamble, if you will, talking about the 4 conditions and specifying that those are the only conditions that justify march-in. And then in the very next paragraph saying, well, but, you know, in order to meet the goals and ambitions of the Bayh-Dole Act, we can also use price. And so these are the conditions under which you might consider price as a factor in exercising march-in. Well, needless to say, the user community, and by the user community, I'm referring to everybody from the generic industry, generic drug industry, to America's universities, rose up in opposition to the NIST guidelines. So we have heard just in the last week or so from unofficial but very reliable channels within NIST that the guidelines are dead, that they will not be finalized. We don't expect that they will be affirmatively withdrawn, which unfortunately continues to do a great deal of damage because now prospective licensees for technologies from universities, for example, don't really know whether or not the guidelines are going to be ultimately finalized. So I'm very hopeful that the next administration will affirmatively withdraw them. And as it did in the prior Trump administration, under the leadership of Walt Kopan, they published a green paper, and they published a very definitive study on the role of IP, and among which they then put forth some proposed rulemaking that said that effectively price cannot be a factor in exercising march-in. And it was all based upon the recognition that it is an ineffective tool. The principle of march-in is that the agency can march in on a license that a university has licensed technology out to the private sector based upon federal funding. Prior to Bayh-Dole, all of that IP was owned by the federal government. So now universities, for example, can license out the technology. But who's going to license that technology if they realize that 5 or 10 or 15 years later, an agency can somewhat arbitrarily decide that the price is not reasonable? Furthermore, the putative purpose of the march-in guidance was to control drug prices. Well, anybody who's familiar with the system knows that the technology that one licenses from a university is basic science. It's usually the mechanism of action. How does a drug actually work? We know that a compound will do something in the body, but it's usually many years of research and a whole lot more IP that's developed privately before you get to a drug that's actually safe and efficacious. And that IP is not reachable through the march-in power. And so that IP is going to block anybody from actually exercising the march-in power to give a new license to another entity. And so, the fact that we're somehow going to exercise the march-in power to lower the price of drugs is really fallacious, because it's just not going to happen. There's going to be another layer or 2 or 3 of IP on top of that. And we're never going to get to the point where an agency is going to be able to license that technology to a generic drug maker, for example. And finally, I would say that the generic drug industry rose up in opposition to it as well, basically in recognition that they need a pipeline too. And if you exercise the march-in power, or at least threaten to exercise the march-in power, those drugs just aren't going to get developed. And so they're going to have nothing to use, to copy, to go generic, and their pipeline and their business model essentially falls apart. So it was very, very, I think, poorly reasoned. And so we're glad to know that it's dead. But I would think that hopefully in the new Trump administration, it will revive the effort that Walt championed the first time around. And I guess, not to put too fine a point on it, but unfortunately by the time Walt got everything together and put out the notice for rulemaking, it was at the very end of the Trump administration. So the first thing the Biden administration did was reverse that proposed rulemaking. So it's all there. Hopefully we can tweak it a little bit and pick up where we left off. And then we would have affirmative rulemaking that says that price cannot be a factor for exercising margin.
Thank you. And Rama, I want to move later on to the more international aspect, but one more question related to the US innovation ecosystem. So in the last months, there was a lot of discussion on the several bills, Prevail, PARA, Restore, that seek to restore the reliability of the US patent system. As a former judge, how do you see these legislative efforts, and what do you think the new administration should do, if anything, with respect to those bills?
Thank you. So there's 3 bills in particular that are pending, and I think all 3, the PARA, Patent Eligibility Restoration Act, Prevail, which aims to reform the Patent and Trial Appeal Board at the Patent and Trademark Office, as well as the Restore Act, which has the goal of bringing back permanent injunctions upon a final ruling of infringement. I think the commonality in all 3 bills is rebalancing leveraging power. I think all 3 of them give leveraging power back to smaller and medium-sized entities. I think disruptive technologies typically occur in smaller companies. They can run faster, and also larger companies that were at some point were smaller companies. So the Patent Eligibility Restoration Act aims to provide more clarity in what subject matter is eligible for patent protection. So things like, it identifies things like mathematical formulas that are not part of the useful process, or mental processes are not eligible for patent protection. As a former APJ, it is very difficult to apply patent eligibility law. Section 101 since 2010. Is it going to be these cases which say it's okay, or is it going to be these cases which say it's not going to be okay? When I was there, we had USPTO guidelines that helped with that analysis. However, it wasn't adopted by the entire globally, the ecosystem of district courts and the Federal Circuit, so it only went so far. So I do think having that type of clarity is going to be very important to provide patent owners with the clarity and certainty. It's important for them to have that clarity and certainty to use patents as a currency and getting resources, investments, and transactions, licensing, et cetera. The second bill that's pending is the Prevail Act. Like I said, it is intended to reform the Patent and Trial Appeal Board. It has provisions for standing, so only someone who has been sued for patent infringement or threatened with a patent infringement suit can file a petition to challenge a patent. It also limits repeated challenges. And there I'll say that no patent, I think, it can withstand infinite challenges. It's not an exact science. So if you have more than one bite at the apple, you can find better prior art, you can refine your arguments, you might get different judges. So that really does not benefit the smaller companies who don't have who have limited resources to engage in protracted litigation. I think another provision in the Prevail Act is harmonizing standards with the district court. For example, the burden of proof from preponderance to prevailing. I think the one provision that I am hesitant about is it says that a judge that was on the institution order cannot be on the final decision, cannot be involved in the final decision. I wonder if that provides inefficiencies because the judge who wrote the institution decision is going to be very familiar with the record and the arguments. So I think that's what I think about the Prevail Act as from my former experience. And the last one is the Restore Act, which brings back permanent injunctions. And I think that's very important to provide patent owners with that leverage of being able to keep ongoing infringement, stopping ongoing infringement, as well as deterring potential infringement. So I think those three bills would, again, like I said, be beneficial to smaller and medium-sized enterprises.
Can I jump in for a second,
Sure.
Yoshka? So just to comment on the last point that Rama made on the Restore Act and injunctions, it certainly would provide, as you say, another tool for smaller companies, but it's really much more important than even that. The bottom line is, just to be very simplistic and direct about it, you can't have a patent system without the right to exclude. The whole point of a patent is to create the right to exclude. It's in the Constitution. That's what the Constitution says. And somehow we have come to the point where we interpret the Constitution that says the exclusive right can be obtained by non-exclusive remedies. I mean, just the tortuous, thinking is remarkable. And the reality is, you no longer have, without the injunction ability, without the right to exclude, it's not actually a property right. And you cannot, as the patent owner, engage in a meaningful license activity in the transfer of that technology from your own lab to the market. It basically becomes a compulsory licensing system that is backed not by your government instrument, it's backed effectively by litigation. So what you have seen, and the threat of litigation. So the perverse outcomes that have come from this last 20 years of this inability to obtain injunctions, you have seen an increase in litigation, an increase in litigation costs, a lengthening of the duration of litigation, of a multiplying of proceedings, of litigation between the district courts and the patent office and the ITC and so on. It is a complete perversion of the patent system or the patent right without the right to exclude, the constitutional right to exclude. So the Restore Act is a one-sentence bill that basically says if you have a patent that the court has found to be infringed, then they have a presumptive right to an injunction. To me, that's critically important. Not to denigrate the other bills, which are also important, but. But I want to emphasize that one.
Yeah, again, endorse and adopt. But to my mind, I think it's helpful for the folks who don't live in our bubble and pay attention to this every day to understand that both para and restore are essentially bringing us back to the situation that existed prior to a number of unfortunate judicial precedents, which really muddled patent law very, very considerably, and I think due to confusion of some subtleties of patent law that tend to escape the average judge. The Prevail Act, I think, is important to bear in mind that that's really, again, not revolutionary. It's important, but it's not revolutionary. It's just fixing some of the unintended consequences of the AIA. And I think those unintended consequences have crept in, and they've done all the things that Andrei mentioned, and they have made life miserable for the patent holder, and particularly the little guy who's trying to elbow their way onto the market and needs the patent system in order to survive. And without that patent system, it's impossible for them to do so.
On PARA, which is the Patent Eligibility Restoration Act, the statute that dictates in the United States what is eligible for patent and what's not, it's 35 U.S.C. Section 101, was written word for word for the Patent Act of 1793. It was written by James Madison and Thomas Jefferson. And it's the same act that's being used today. Congress has not legislated on that issue since the 18th century. And as a result, you have courts that can, to some extent, be forgiven for struggling on how to fit 21st century technology, whether it's AI or DNA sequencing or whatever it might be, into an 18th century statute. So Congress cannot abdicate this critically important role. These are difficult questions. What do we want to grant patents to? What types of new things do we want to grant patents to, and what do we not want to grant patents to? Not everybody agrees. But that's the whole point of a legislative body. You have to have that debate. Come forward with all your thoughts. It's time, 250 years later, to modernize.
Please.
Two observations. First, I just wanted to talk about the status of those three bills, and maybe my co-panelists can help me out here. I believe PARA and the Restore Act haven't made it out of committee, and the Prevail Act is actually going to full vote in the Senate.
The Prevail Act has made it out of committee on an 11-10 vote in the Senate. The other two have not been brought up to the committee yet, although there is going to be a hearing next week, from what I understand, in the Senate on the Restore Act. However, keep in mind, this Congress is going to end at the end of this year. All those bills get wiped out, basically, and they have to be reintroduced if the sponsors want to have them considered again in the next Congress.
And they're bipartisan in support, so perhaps they will come back. I also want to note that just this past Friday, China's patent office requested public comment on AI-related patent applications. So all kinds of issues like patent eligibility of AI technologies, as well as the patentability of AI-assisted inventions. So they're grappling with these issues as well because they want to have strong IP protection so they can attract innovation to their borders.
Yeah.
And you'll forgive my cynicism, but when the Chinese government asks for public comment, say no more.
And it's a 1 week window in which you can provide comments.
Plenty of
And
time.
if you answer the way we don't like, we'll see you later.
These are great points. And actually, looking a little bit outside of the US, Director Iancu, what are the most concerning developments in the field of intellectual property rights that you have seen in the last years and that, in your view, the incoming administration should address immediately?
Yeah, so again, high level, the biggest concern is a failure in Western governments to recognize that patents should be treated as property and the administration should enforce that point, not only here at home, but in trade agreements overseas. More specifically, I'm very concerned by the attempt by the Europeans to reinsert themselves even more into the private sector and over-regulate yet again in the area of standards and standard essential patents as one example. There is this proposal in Brussels that, first of all, categorizes patents on standards-based technologies as being in a special category, and therefore needing further regulation. So they want to create an intermediate, yet a new court and yet a new court proceeding that you have to go to in order to determine if your patents are actually essential to the standard and what the value is before you can actually go to court. That proposal has made it quite far in the European government, and in my opinion, it would be devastating to innovation in that space. It would be even worse if it trickles over into the United States and something like that is done here as well. By the way, there are a lot of crazy things about the European proposal on the standard essential patent thing, but here's the craziest. They want to put this new court, let's say, that's to review patents. They want to put it at the European Trademark Office. So that's like the first signal that, maybe that's not the best idea. But there are many problems with that. There are proposals in Europe as well to curtail continent-wide injunctive relief there as well, and effectively do what we do here in the United States, which, as we said, we're not in a good place right now, and we're trying to restore the injunctive right here in the United States through legislation. But at the same time, several European countries and other countries around the world still have a very robust injunctive relief system. Germany is one example, and others. So now there is an effort at the European government level in Brussels to dictate a more, quote, flexible approach across all the governments, and therefore not have injunctive relief be available in all instances of infringement. So that is very detrimental as well. And because they cannot be left out of regulating anything that comes before them, the Europeans also are working really hard to overregulate the AI space and the data space. We've known that for a few years. That's a concern. And all of these are concerns to innovation. It depresses innovation, okay? And the concern, as being a former U.S. government official, the concern here is that a lot of those efforts will bleed into the United States as well, whether it's on standard essential patents, the overregulation of AI. We saw it in the Biden administration with this absolutely monstrous, humongous executive order on artificial intelligence that attempts to overregulate in many ways, and the Patent Office already issued AI guidelines for patents that I've publicly said that can be quite problematic. So just the bleed over into the United States of all of these concerns. And then we're facing, the United States and our Western trade partners, we're facing the rise of China in the technological world. And we have to be able to compete. And we have to be able to out-innovate them. And if, while we're trying to compete for the technologies of the 21st century and beyond, and our inventors are struggling to get in the investments necessary to attract the capital, to start new companies, if at the same time the rule of law is being eroded in the West, we already are having a tough time keeping up with the Chinese innovation ecosystem. And if we continue to erode the rule of law on the laws that protect and incentivize that innovation, I think we're going to be in big trouble. And this is a today issue. It's an emergency. It's not a year from now or 4 years from now. We cannot wait. Already, the Chinese are outpacing us in many of technologies of the future, or are giving us a race for our money in some of the rest, like AI, for example. But in many other areas, they already have taken the lead. And we must bring all hands on deck to innovate as much as we can and unleash the creative power of Americans. And that cannot be done while you erode the rule of law.
Yeah, great point. Brian, in your view, what role should the international cooperation play in this discussion about IP rights? Do you think the administration should strengthen the role of the US in leading the global policy debate about intellectual property rights rather than getting influence from abroad?
Yes, I think we should go back to being the global leader, advocating for strong IP rights. That was the role that we played throughout much of our history, but particularly the late 20th century. And so we need to get back to that place where we're convincing the rest of the world that IP is an asset that every country can mine. Every country has intellect. Every country has people with creative instincts, and they don't need vast natural resources. They've got it within their people. And so we should be encouraging people, because it's the best thing for all of mankind, that everybody is encouraged and incentivized to go out and make the world a better place, and that they will get a return on investment for doing so. So I think it's very important that we work with our international brothers and sisters, and that we lead them once again in encouraging a strong international set of norms around IP, because increasingly IP is an international game. I mean, nobody's really just getting a US patent anymore unless they can't afford to do more. I think that I'm often reminded in response to that question of a workshop that we had at the meeting of the Licensing Executive Society International, which was in Madrid, Spain in May. And we focused on the UPC. And time again, we heard from industry representatives at panel after panel saying, yeah, we're coming to the UPC now because we can get an injunction, we can get a prompt resolution, and we just base our global settlement agreement based upon what comes out of the UPC. Well, what does that mean for us as a nation? I think that's very, very worrisome, because what it means is that we are ceding the leadership on at least precedential law, if you will, to European courts. And we know, for example, from the SEP guidance that came out of Europe, that Europe isn't always in alignment with our view of property rights. And so the idea that increasingly international companies are going to the UPC to decide patent cases, and by definition then, less so to US courts, it means that we're losing that leadership. So we need to fix a few things. We need to fix things with, having to do with the PTAB. The Prevail Act would be a good way to do that. But most importantly, we need to do all the things that Andrei said that we need to do, which is, this is an all hands on deck. We need to fix our IP system. We need to make patents reliable, durable, enforceable in the US, because for all intents and purposes, we are still the dominant market-based economy in the world.
Thank you. Rama, we have already discussed AI, but mainly in relation to technology, patents, but we have seen the increasing use of AI in creating content. So how do you think copyright law should address these, let's say, new challenges, but opportunities also presented by AI-generated works? What frameworks or guidelines shall the incoming administration keep in mind to ensure a fair protection of creators, while of course also fostering AI development?
I think AI is a double-edged sword when it comes to creativity. It can amplify creativity at the same time. It can undermine human authorship. I think there's definitely two issues: whether the data that's used to train AI models and the output that's generated is infringing existing copyrights. And the second issue is whether AI-generated content itself can be patentable. On the first issue of copyright infringement, I think human authorship and creativity is very important. So we need to make sure that we focus on that. And so I think content creators need to be compensated. I think they should have the power to consent if their content is going to be used to train AI models. And I think the guiding principles should be transparency and informed consent. The main issue of using data to train AI models is whether it's fair use, a legal doctrine that allows certain copyrighted material to be used without permission, for example, for scientific research. I don't think that argument can be made for data used to train AI models just because of the licensing market that's developing. But I do think that content creators should be compensated. Again, we'll always need human creativity, so I think we should establish guidelines for training AI and licensing frameworks. With respect to the second issue of AI-generated content, I think that's still an issue that the Copyright Office is providing guidance on. Currently, the Patent Office has doubled down on saying that any AI-generated content that's automatically generated, autonomously generated, is not entitled to copyright protection. But if AI is used as a tool and the human still provides significant human creativity, that the whole work might be entitled to patent protection. So I'll give you a couple of examples. They did deny copyright protection when an applicant had human-written, human-authored text, but they used AI to generate images for that text. And they said that the whole work could be copyrighted, the human text could be copyrighted, but not the AI-generated images. I think that there's a potential, I'm not saying that there is, but there might be a potential for inconsistencies between the patent approach to AI-assisted inventions as well as and the copyright approach to AI-assisted copyright protection. So, for example, with respect to prompting an AI model, the USPTO guidance put out guidance on when when a human uses an AI to prompt an AI model in coming up with an invention. And again, there's a requirement that you have to name a human as the inventor on the patent application. And they said prompting, depending on the type of prompting and how much significance input there was, that might be entitled to patent protection. The Copyright Office, in its initial guidance, said that if you prompted an AI model, the model's interpretation of that prompt and the output generated text, video, audio, whatever, was generated autonomously by the AI and likely not entitled to copyright protection. So I think on the edges there might be inconsistencies, and I don't think that would be good for the entire IP system. And I also want to point out that China has been very liberal in its copyright protection, and in a ruling, I believe it in 2023, found that a human who used Stable Diffusion to generate images was entitled to copyright protection as well as damages when that image was used without permission.
Are we okay on time? I have a comment on this.
Please go ahead, and then I have just one final question.
Okay. So look, so AI is a new technology, newish technology. That's, I mean, it's been percolating for quite some time, but just coming in full force now, and there's going to be much more in the coming years. It is perfectly appropriate to have a public discussion now. That's the whole point of our legislative system and administrating system, to have a discussion now as to what is protectable by patent, copyright, whatever, what is not, what are the pros and cons, and so on. But we need to know the rules of the game, of the road. We need to know the rules. Industry needs to know the rules, because otherwise it's very, very difficult to have investment at scale, one way or the other, whether it's protectable or not protectable, in which, without knowing, you have an uncertain situation in the rule of law, and that's not a good thing. So I think it's incumbent upon government to figure out what exactly the delineations are like soon. And the next 4 years are going to be critical for this in this particular area. And it's not clear yet what the right answers are, right? I mean, I have my views, Rama might have her views, and other people have their views, etc. Different industries will have different views. That's fine. We have to have the discussion, and then decisions need to be made. But I will say this. I think it's really important to keep in mind the role of intellectual property protection in general. And it's going to be applicable here as well, which is, number one, you need to be able to incentivize investment in the new area of technology. So the question is, will IP protection for AI-generated paintings, for example, or songs, will that incentivize creation or not? Okay, that needs to be resolved. But keeping in mind that question. And the second really important question is that IP protection facilitates commerce of the intellectual, of the technology or the art and so on. IP is, or patents, for example, are the currency of innovation. You can not just incentivize its creation, but because you have the umbrella of the rule of law, it facilitates collaboration and transfer of that technology from one entity to the other, from the creator to the consumer. That's going to apply to AI-generated creations as well. So when you make these rules, when government makes these rules, it needs to ask itself, will these new rules that we're implementing facilitate that commerce? For example, will a big movie studio that uses a lot of AI-generated content, maybe all of it, okay, picture after picture after picture of kind of like in a cartoon movie situation, and now you have a full feature-length movie that's AI-generated. If the government, it's perfectly fine for government to say that that is not protectable because we have to protect, quote, whatever they deem as human creativity. Okay, that's a particular point of view. I'm not saying I agree with that. But if that's the rule of the road, will the movie studio make the investments necessary not just to make that movie, but then to display it and send it out to theaters and commercialize it, knowing that as soon as they put it out, it's going to, all revenue is going to disappear, and so on. And if you say that government says that that is not going to be protectable, you either have to decide that it's fine if it doesn't get commercialized, or you have to come up with another system that incentivizes that commercialization. But the bottom line is these discussions need to be had now, and keeping in mind the ultimate goal at the macro level of the United States generating as much new innovation in this new space as well, AI, and competing with China and others in this new domain.
Also, just wanted to point out that the Copyright Office is scheduling new guidance to be issued. So I think some of these issues some of the guidance might be refined.
And I would add that, we've seen this movie before, no pun intended. What was it, 40, 50 years ago, we saw the advent of biotechnology. And everybody was concerned about, are we going to allow the patenting of DNA-oriented technologies? And the parade of horribles began, and there's going to be Frankensteins walking the streets, et cetera, et cetera. But the US bucked that trend and basically said, yes, DNA-oriented inventions are patentable, and our biotechnology industry went like this. In Europe, didn't go anywhere. Then we had, 20 years later or so, 30 years later, we had nanotechnology. And everybody said, well, this is a whole new physical phenomenon, if you will, what takes place at the nano level, et cetera, et cetera. And so the Patent Office, again, was a little bit flummoxed about how do we deal with the patentability of nanotechnology. But, we addressed it, we dealt with it. And nanotechnology boomed in the US and not quite so much elsewhere. But each time, we've done it in a very open-ended, smart, savvy, economic forward way, and our industry has boomed. And so I think we have to take the same approach with AI.
Yeah, great point. I know we are running out of time, but just a last question. So as the new administration prepares to appoint a new director for the USPTO, what do you believe should be the key priorities for this appointment to ensure that the office effectively supports innovation and economic growth? And in addition to that, do you think that there is a need for a dedicated position at the White House to oversee and coordinate the intellectual property policy across the various agencies? Maybe we
Who are
can
you
start.
asking? Me? What do I know about these things?
I mean, all of you, but we can start with you.
So, key quality of the new PTO director is to make sure that they do what the first Trump administration did on IP. I don't know why I would say that, but no, in all seriousness. So look, the PTO director job, some people don't appreciate the importance the PTO plays in our economy, and it's a weighty position. Okay, so it really does have, like the position name suggests, there are actually two jobs in one, right? You have a policy job to advise the administration on all these really important IP issues, whether it's patents or even copyright or trademarks, obviously, or new technologies like AI and so on. So there is this you need a really experienced person to understand the implications of these policies in the real world. Really important to have somebody who is grounded in industry in the real world and either participated in that industry themselves or worked with clients from a broad-based type of industries. And the second aspect is, as the director of the office, you're the CEO of a 13,000 person, $4.5 billion enterprise. So you need somebody that they can, have that CEO role that, has the experience, the demonstrated leadership qualities with large organizations, meeting budgets and so on. Keep in mind that this is not just your good old regular government agency, where if you screw up the budget, that the taxpayer will be there to back you up. That's, the PTO is user fee funded. There are essentially no taxpayer dollars that go to the PTO. You have to manage it expertly and professionally to make budget and not not make mistakes there, among many other things. So look, the qualities I think in a director is, on the policy front, somebody who understands the real impact on the intellectual property policies to the creators, actual creators in the space. Okay, and President Trump in the Republican National Committee platform that was promulgated at the convention a few months ago made it very clear that his administration is dedicated. It says it at the beginning. It's the motto of the platform: dedicated to the forgotten men and women of America, with lots of provisions for the working men and women of the United States, the small businesses, the entrepreneurs, the startups. They will turbocharge our economy. So the director needs to understand and have firsthand experience with these types of enterprises and what they need to actually succeed at turbocharging America's innovation economy. So that is whoever it is has to have demonstrated leadership in that space, together with, as I said, the experience of the management experience that's critical as well.
Great.
I think it's important to have someone to lead the U.S. Patent and Trademark Office that has practical experience with procuring patents, experience with litigating patents, experience with commercializing them, for example, licensing. Without that practical experience, you don't know how policy and regulation guidelines are going to be implemented, what the effects are going to be. And so we don't want policy or regulations or just that's going to be academic. We actually want them to be efficient and useful. And you can't come up with those sort of guidelines and policy without actually having done it. So that's what I would recommend. And as far as your second question, yes, I think it would be very useful to have someone who oversees all the different IP equities across departments and agencies that are currently siloed, so that they can be consistent and work together, and then also be, like I said, integrated into broader competition and innovation policies.
Just on that last point, because I didn't address it in my, I'm not in favor of creating yet another position. I am in favor of consolidating government functions. So to the extent the proposal is to have a position that coordinates all the IP functions in government, which I think is a good idea, it could go to the PTO director. Of course, it depends who the director is. But overall consolidation is important. I have said in the past that I do think IP and innovation is so important. I do think it would be longer term a good idea to consolidate the various IP aspects of government and create a cabinet level position and department, have a department of innovation, or a department of innovation and intellectual property, or a department of innovation and creativity, something like that, with a secretary of that department, and the various that's in the cabinet, and the various functions, patents, trademarks, etc. Enforcement would be within that at that level. It is IP drives half of our economy, okay, and something like 90% of assets of our Fortune 500 companies are in intangible assets. Not to have a cabinet level member that's in the president's ear on this specific issue, I think it's a lost opportunity.
Thank you. And last but not least.
Thank you. Well, I was in an event on Tuesday where the same question was asked, and the answer was clone Andrei Iancu.
Thank you. That's funny.
But that creates certain problems in terms of consent, and then growing it from a petri dish all the way up to what we have here. So,
Or digital replica.
oh, that's a good option. Yeah, worked in Star Wars.
The AI answer.
Yeah. So at any rate, I think, I agree with everything that's been said. It's got to be somebody who has some working appreciation for how the IP system actually works, start to finish, and also somebody who recognizes that the issuance of the patent is not the end of the road. It's the birth of an asset. And so that asset can then go on and fuel new industries, fuel new businesses, fuel jobs, and fuel our economy. And so I think it's very important that we focus on somebody who's actually seen the system, and I agree that it shouldn't be an academic or somebody who's a political appointee just to fill a slot. And I don't suggest that that's likely to be the case. I think, as we saw in Trump 1, it was very carefully decided, and it was decided very well. And so I think if we follow that path, we'll be in good shape. As for another office, I share Andrei's concern in the sense that it can create some mischief, it can create silos, it can create, I think, potentially discord between what happens at the patent office, what happens at the copyright office, and then what happens in the White House. Because we have different chains of command right now, technically speaking. The Patent and Trademark Office Director answers up through Secretary of Commerce. And so who ultimately answers to the President, of course. But I think we would need to think very carefully about how that's done and what authority they would have. But it is incredibly important, and it deserves some thought.
Great, thank you. Well, with this, I think we have come to the end of our discussion. I would like to thank our speakers for their invaluable insight. I would also like to thank the Hudson team for helping to put this event together. And of course, I would like to thank our audience, both here and online. Thanks everyone for joining us, and have a great day.
Thank you.
Thank you.